right, thank you for staying with Daybreak. Let's continue this discussion now. Talk about the BBI Supreme battle. It's a 3-day marathon hearing, and there's something that happened there. Amicus Curiae saga at the Apex Court. Let's start from there. So, before the hearing of the appeals began, 2 lawyers walked out of the court when they were blocked from addressing judges. Martha Karua and Dudley Ochiel protested the decision by Chief Justice Martha Koome not to allow them to make oral arguments. So the two represent the members of the Linda Katiba, which sued the government 2 years ago in efforts to stop the proposed constitutional changes. Senior counsel, is that the protocol, or is that the question of the chief?
Thank you, Trevor. I noted that the 2 advocates appearing for the 2 clients, the Amici Curiae, was stopped from addressing the court. Now, an amicus curiae, that is one, amici curiae, 2, basically are individuals or advocates who come to court for purposes of standing with the law. They do not appear for any side. They are neither for the petitioners nor the respondents, but come to court to submit on pure legalistic questions. The appeal against the decision of the Court of Appeal on the BBI, basically an appeal brought under Article 163(4)(a) of the Constitution, a direct appeal to the High Court on matters touching on the interpretation of the Constitution. Now, it is expected that whenever amicus curiae appear in court, they are independent, they are fair, and they are solid on legal questions. In the case before the court, the 2 amicus curiae, this is senior counsel Martha Karua, and a lawyer
Dudley
Ochiel, who is a very good advocate by then, my friend, a very good advocate. Both were stopped from submitting. I think the argument by the court was that the Supreme Court has considered their arguments. And the Supreme Court, in view of time, will only allow parties who are opposing and or supporting the appeal before the Supreme Court to submit, because their submissions are on record. In the Supreme Court, under the new rules, the Supreme Court judges can give directions on the manner in which parties proceed before it. Previously, amicus curiae, and I've appeared as amicus curiae for the Law Society before the Supreme Court, and of course in other contentious matters, we are often allowed to submit. This is an unusual situation where the lawyers were denied their right to submit. I would have expected, and let me say this, the court should have been fair to the parties. Once they are admitted to the proceedings, and because they participated both in the High Court and the Court of Appeal, they should have been allowed to submit, because intricate questions before the Supreme Court, for instance, on the basic structure doctrine, touching on all the 18th chapter of the Constitution and the 6 schedules of the Constitution, are serious questions of law. And I believe that these parties have a public interest on the questions before the court. They have a duty to highlight the law for the sake of the public. They should have been even given 10 minutes or some little time to at least highlight the submissions that they have filed before the court. I think the court should have been perhaps fairer to these parties, ought to have allowed them to make submissions. Now, let me also say this. The BBI appeal also touches on many questions, not just the basic structure, but also on questions on, for instance, the legality of the IBC. These are serious questions, fundamental questions of law. The constitutionality of the IBC, whether there are statutory framework that will have allowed verification of signatures, quorum issues,
the presidency immunity.
The presidency, the immunity, compliance with Chapter 6, those are serious questions of law. They should have been allowed to at least have some time to submit.
Okay, but then the walkout, does that signify anything?
I think it's just an expression of discontent. I don't think that Senior Counsel Martha Karua can be held in a space when she has been clearly told that she's not going to submit in that space. she walked out on Moi, she could walk out of court. I don't think I'm surprised.
Okay.
I think that lawyer Dudley Ochieng must have been disappointed because he usually prepares for his cases. Okay. I've done many cases with him. He's usually very, very prepared. He's a good mind. Okay. And I'm sure he was disappointed.
Okay. Omari, I've just learned that it's amicus. You said amici.
When there are two.
When there are two.
Yes.
Yes.
One is amicus, the other is when there are two or three amici. What is coming out of yesterday's episode is now going to be a comparative a look at the Supreme Court under Chief Justice Mutunga, the Supreme Court under Chief Justice Maraga, and the Supreme Court under the Chief Justice Lady Justice Martha Koome. In the two previous Supreme Courts, the role of the amicus was very pronounced, extremely pronounced. In presidential elections, those are the other matters that have become the petitions that have appeared before Mutunga 1, Maraga 1, Maraga 2. The amicus were given a critical role. Some of these election petitions were filed through the civil society movements, AfriCorp and the others. The role of the civil society in the question of public interest is now what is coming up in place. Counsel Dudley Ochieng is a renowned civil activist lawyer. He's actually the face of Katiba movement. And landmark decisions on public interest, he's a very good lawyer, thorough lawyer. Two, Senior Counsel Martha Karua is equally known to be from that question. You just put that with the current Chief Justice who came from that civil society. There was an expectation that this civil society group would be given time. They carry a serious constituency. The composition and execution of the mandate of the Chief of the Supreme Court has raised two questions. One, in an ex parte hearing, the judges sat and allocated timelines. To the exclusion of the parties. Yesterday, the first question that they had to deal with was that the parties had complained, AG had written a letter, Senior Counsel Orengo had written a letter, everybody had complained that you sat unilaterally, allocated time. Other parties were not given time. Was that an oversight? The Supreme Court is starting on a wrong foot. The law as it is, there was supposed to be a conference where, a trial conference, where the parties could have appeared and argue on time allocation. That is one mistake that the Supreme Court has started. So people are saying, is this court responsive? Is it going to listen to people? Or the court is saying, we have control and we'll tell you, Professor, 2 minutes without hearing Professor why he needs 30 minutes. Number two, the greatest blunder was yesterday. They denied the civil society audience. And the civil society reacted by walking out. What will it look like? Funding for the judiciary. Funding from the judiciary. My good senior will tell you the judiciary receives money from foreign entities, trainings and all these things through the civil society. The message the civil society, the Supreme Court is saying, we do not need the civil society here. They are irritants. That walking away, if I was part of the Supreme Court, we would have recalled the two lawyers, reconsider our decision, allow them time. Cases have been proceeding up to midnight. really the question of time, a critical element of the law of this country, the civil society, was cut off. Credibility of this process, and I'm telling you, the civil society are going to the trenches to fight the Supreme Court. That fight is not going to be good for the dispensation of justice. And as we are talking here, the 7 judges are listening, the administrative arm of the judiciary is listening. Let them reconsider and bring the civil society in.
Yeah.
The space about constitutional interpretation of the BBI is a product of the civil society. What they are deciding was born, conceived, fought for, bloodshed by the civil society.
Yes.
How do you exclude them from their own baby? That is the politics of the decision yesterday. And you'll see, Trevor, the dynamics that are going to force when the civil society will start organizing demonstrations and trying to attack. That was a wrong mistake.
Yeah.
They are our learned judges, our learned lords, the lordships. That was a wrong decision, which is going to impact on the politics that surround. How are we now going to deal with the next hot question? 2022 presidential petition. The way they handle this matter. Number 3, remember, Mother Karua, Senior Counsel Mother Karua, at one time was thrown out of the Supreme Court. In the election petition against the governor, Anne Waiguru, she had to get a decision in the East African Court of Justice in Tanzania. So the question is, if our Supreme Court is supposed to be the final decider, it decided the election petition, but she went and got it. Are we likely to see Dudley Ochieng and preparing for an appeal of the decision of the BBI to the East African Court of Justice? Are we going to see a prolonged argument where they are filing that they were never heard, and the decision of the East African Court of Justice binds the Supreme Court of Kenya? That is an avenue that the Supreme Court yesterday opened up to unnecessary litigation. They could have been given 10 minutes, let them represent their critical constituents, let their decisions be dismissed. If it is true, the Supreme Court has already read and is going to rely on what they have written, why then discriminate? Why are others being given time to highlight the question of discrimination? So in my own view, as Senior Counsel finishes that matter, the decision yesterday needs to be relooked administratively and include the civil society in this matter to give it the international appeal, to give it credibility, and to give it the satisfaction that everybody is on board.
But Senior Counsel, Chief Justice Martha Koime's argument was that they were not substantive respondents in the appeal. They joined in the High Court as amicus curiae and therefore should remain as amicus in the appeal. You know, does she have a point?
You know, an appeal must be looked at in totality. Every party to an appeal plays a role. The right to fair hearing espoused or provided for under Article 52, and if you look at Article 25(1) of the Constitution, is non-derogable. You cannot deny a party the right to a fair hearing. Now, that there are parties that they have been part of this process from the beginning, and that they contribute to this process. They've contributed to this process right from the High Court to the Court of Appeal, and they have an expectation out of this process. The expectation to be heard, the expectation to pronounce, to speak to the questions they have filed, because they've filed documents even as amicus. I think those are the sticky issues. That if you extrapolate all these constitutional questions, then you'd arrive at a decision, of course, to give them a leeway to be heard, because they filed documents in court. You cannot, on the one hand, file documents in court and then come to court and you're told, no, you cannot be heard because you're merely an amicus curiae who supports both sides, because you're supporting the law, you stand for the law. So the Supreme Court is then saying that we do not need parties that are espousing legal and constitutional principles here.
Yeah.
We only need parties who are either challenging the decision of the Court of Appeal, yeah, or supporting the decision of the Court of Appeal. I think that's a bit narrow, yeah, because the BBI appeal is about, first, it is a first. It is a first of its kind because it deals with the manner of amending the Constitution as provided for under Articles 255, 256, and 257. The popular initiative under 257, which is under question, and whether the president can originate a constitutional amendment, whether the steering committee was constitutional, as found by the Court of Appeal. There's a cross appeal on that question.
Yeah.
And you know, you're dealing with a first. It will forever define how the Constitution of Kenya can be amended either through the popular initiative under Article 257 or through the parliamentary process under Article 256, because those parameters must be established. Whether the committee is legal and whether BBI then can be given life. Remember, some of us who stand with the BBI and who stand with the finding of the Court of Appeal on the illegality of the committee, and who stand against the finding by the Court of Appeal that the basic structure doctrine applies to Kenya, would want to see some of the proposals in the BBI amendments go forward beyond the findings of the Supreme Court. And therefore, because we stand on this bridge that supports BBI, we'd want to see a comprehensive decision, and would want to see every party to this process participate and raise all questions. Because remember, beyond the Court of Appeal under Article 163(7), there's no other court. This is the final court insofar as our questions are concerned. Other principles, of course, will find their way to the East African Court of Justice, and that is why we are, Mr. Murray is saying, yeah, that on questions of the right to a hearing, you cannot, of course, the court probably will be saying they'll not be condemned, but it is fair, only fair, to hear a party on any question, because this is a question of national importance. Once the Supreme Court finds that the popular initiative is initiated or can be initiated by His Excellency the President through the committee, as was found by the Court of Appeal, once the Supreme Court finds, for instance, that the basic structure does not apply to the amendment of the 18 chapters of the Constitution and the 6 schedules, once the Supreme Court finds that the IBC was properly constituted for purposes of verifying signatures and for purposes of undertaking these activities, if it overturns the decision of the Court of Appeal, then the BBI process will recommence. It will have a fresh breath. And you can imagine what the advocates will feel, what Martha Karua and Luduldi will feel, that we were not heard, we were ignored on these fundamental questions. Yeah. And that is why, in my view, that at the Court of Appeal, at the Supreme Court, the court should always strive to hear all parties. Okay. My learned friend has raised another important question. What does this portend for future litigation at the Supreme Court? Does it speak to predetermination, where judges will sit in chambers, make a decision, and come and read out the verdict? You can see the fairness, the question, then that goes to the question of confidence in the court. These are crucial issues. How do you set time? Yeah. At the Supreme Court, how we set time is this. The matter is mentioned before the judges or before a single judge or before the deputy registrar, who then gives time. The judge will then invite arguments from counsel as to how much time you will take. And we will tell the court, we will take 30 minutes or 1 hour. Normally it's 1 hour or 1.5 hours. The court say, no, you take 45 minutes or 1 hour. Then you agree on the time, so that you prepare to submit within the time frame set out by the court. Normally when time is imposed by the court without a hearing, it's a little difficult, because then you find advocates, some of the advocates that have trained like Jackson Awele, you know, they come to court, they have very good points, out of my training, of course, and they don't have time to make those submissions.
Yeah.
And I think George Oraro Senior Counsel comes to court, he wants to make the point, very good arguments of basic structure, but he doesn't have, you can see that he needs more time.
Yeah.
To make his point. Githu Muigai Senior Counsel comes to court, makes arguments on the IBC. You can see he needs more time. So I think that is why time is perhaps everything in court. Okay. You need to be given time. And let me tell you, Trevor, at times an argument may sound simplistic on paper. Someone has written submission, say it's 3 lines. Yeah. But when he's given time to orally highlight, then the court is able to see the argument. At times the argument is never apparent on paper, never. It is only apparent when the advocate makes the argument in court. It's different when Omari writes something before court, when you do those pleadings, than when you go to court to submit. It makes a whole world of difference.
Okay. Omari, what is the role of the amicus curiae anyway? Because if Chief Justice Martha Koome says they're not substantive respondents to the appeal, what should their role be? Should they then be allowed? Because according to her, they should have just remained as amicus, because that's how they joined.
The role of an amicus, legally defined, is somebody well-grounded in law, who brings an objective view, an objective legal view, a philosophical understanding of certain legal questions to assist the court arrive at a fair and just decision. They are not partisan. The people in court are partisan. There are those ones who are saying prop BBI to death. They see nothing good outside BBI. There are those, the others, saying BBI is as bad as poison. We don't want to hear anything. The amicus is supposed to come and provide a middle line, a legal philosophical middle line that, yes, these guys' arguments, yes, these are right, these are right, these are right, these are emotional, these are non-issues, these are political matters brought here. From this other side, the same. But based on that, these guys failed to look at these decisions in India, these philosophical writings in these books, these journalists, these journals in this journal, this research that has come out. So the amicus is a neutral person in between the two protagonists. He is also not pro the court. He is giving the court material that might not have been brought. This is an adversarial process where each party only gives the material that supports their case. The judges, now under the Kenyan law, have researchers. The researchers are also not very objective, because sometimes the research team looks at the philosophy and the thinking and the jurisprudential school of thought of the judge. And they do research based on what the judge believes in. There are several schools of jurisprudence. The ones I teach, you know, Professor stopped teaching at Moi University. He handed over the baton to me to teach at Catholic University. I still teach, Prof. I've not stopped. So those schools of thought are in different judges. Yeah. So these amicus now neutralize the judge's philosophy, neutralizes these two protagonists' philosophy, and brings a sober argument that represents the unrepresented. Actually, an amicus represents the unrepresented. And therefore, the court cannot deny such a critical issue. Worldwide, the role of amicus is growing. Yeah. Because of the value they bring into. Listen to Professor Githu Muigai as an amicus in the presidential election. Serious research, serious argument that really, even if the other parties decide, they say, no, that argument is sound and it's based in law. So in my own view, as the professor says it, the amicus role has now become academic. Okay. The decision of the Supreme Court binds all courts downwards. With one stroke of the pen, the role of amicus in this country's courts has been diminished. The Supreme Court's obiter is that those words they say, they are not substantive, but they say binds the lower courts. Lawyers are going to object to any amicus joining any matter because they say the Supreme Court found out that you guys are busybodies. And that is why I'm saying the decision yesterday, because the Supreme Court is not functus officio, is not close to this matter, they can revisit and say, out of public outcry or out of review on our own suo motu without being prompted, the amicus join in, let us hear your input in the final stages. That will help the jurisprudence and the growth of the law in this country. We are looking at Article 259, how the law should be interpreted in a purposeful manner that promotes the growth of law. Did the jurisprudence yesterday close that growth? Yes. And that is why I'm very, very passionate that with a simple statement that they were defendants, let them argue, dismiss their arguments on the basis that in this High Court, you are a respondent. In this Court of Appeal, you are a defendant. Here, you can't, but let them be heard. Okay. Do you know, Trevor, what the question is? Yeah. The right to be heard. Yeah. Is so sacrosanct because nobody knows what you are going to say. The court must allow you to say that rubbish, then dismiss your argument. But you cannot be technically refused. When we had the old constitution, the Court of Appeal was the apex court. And you arrived there, the rules were, the cases were decided on technicalities. We moved in 2010 and said cases to be determined on merit. On merit. Yeah. This is a fundamental question of law that touches on very many chapters on the Bill of articles on the Bill of Rights. What does the Constitution provide? Even the court can hear you informally without any formal pleading filed. That is the Constitution of this country. Okay. Why? Because Kenyans said this old man might not be a lawyer. You remember there was a guy from Suna, Migori, in the High Court. He had no legal knowledge, but he was heard. His presentations were dramatic and what, but within it, the court picked one or two issues. Nobody's contribution is immaterial, is irrelevant until it has been heard. The right to be heard is so critical, and it goes to the core of Article 10, the principles of good governance. The court failed in applying those principles, and they technically stopped a critical leg in this matter.
Okay. Senior counsel, what is the effect of the ruling, whichever way it goes? There are those who argue that there can only be three rulings. Either the Supreme Court will uphold, or will reject, or uphold some and reject some. What is the effect of the
that is a correct position, Trevor. The Supreme Court, there were findings by the Court of Appeal, and the findings by the Court of Appeal that have invited cross appeals include the findings setting aside the High Court decision that the president is subject, or a sitting president can be subject to proceedings while he's in office. That's one finding that is important.
Yeah.
There is a second finding of the Court of Appeal, because the appeals are against the finding of the Court of Appeal.
Yeah.
The main findings are on the application of the basic structure. That's number one. The basic structure doctrine, I think the argument was made yesterday by George Oraro. The substantive appeal against this finding by the Court of Appeal is that the basic doctrine applies to the amendment of the Constitution. Now, the basic doctrine structure means that to amend the Constitution of Kenya through a popular initiative under Article 257, you must go through the 4 processes. That is exercise of primary constituent power, having a legal framework, collecting views, having county assemblies accept, of course, that is the half of the total number of county assemblies, then of course a referendum.
Yeah.
Now that is the key, in my view, that is the cornerstone of this appeal.
Yeah.
Because that finding will go to the question as to whether it will be possible to amend the Constitution going forward, as to whether BBI will proceed going forward at all.
Yeah.
If the Supreme Court upholds the decision of the Court of Appeal that the basic structure doctrine applies in Kenya, it means to amend the Constitution you have to go the full hog of invoking primary constituent power by getting the people to be involved from the beginning to the end, where you shall have a referendum. Now that is the implication of that process. Now let me say this. That would then mean, the implication then would be that if you want to amend the Constitution, or if BBI has to go on, then BBI must reinvent by going back to the beginning of the process. The only advantage is this. Remember, BBI has intended to amend, or had within it, 74 articles in question. 74 articles of the Constitution were supposed to be amended. The Court of Appeal found that the committee that was constituted by Excellency the President was a legal entity. Now that's a strength. If the Supreme Court upholds the legality of the committee constituted to commence the process, that would make it easier for the process to recommence. Because what will happen is that we will then begin from the committee and then comply with all these findings and lead to a referendum. Of course, there is the other fundamental question of the unamendability of Article 89. Article 89 basically is on powers of the IBC and whether it was possible for the BBI team to pre-create the 70 constituencies that they created.
Yeah.
Remember, the Court of Appeal found that was unamendable, that you must go through the entire process of amending the boundaries, the review process as provided for by the Constitution, before you create boundaries. You cannot commence by giving the number first and then going, you go through the process first, then you have the number, as opposed to having the number first, then going through the process. Now, that hitch, that finding is also fundamental. If the Supreme Court upholds that decision, then the other articles of the BBI can proceed with amendment excluding the 70 constituencies, because that would then go through the process designated by the Constitution and follow keenly on the role of IBC and all that.
Yeah.
There is one, in my view, and I think the court will set aside this one, is on the powers of the IBC and on the quorum question. Because there was a constitutional decision. I think I did that case in the High Court. The court found that the IBC could exercise its mandate. And that is how we did some elections in Baringo with the 3 commissioners, Commissioner Chairman Chibukati and the 2 commissioners. I think that one will be easily set aside. That one I can tell you for sure you can take that to an M-Pesa agent.
Yeah.
That's a sure bet for the Supreme Court.
But should it be upheld? Does it mean that all the other elections that were done with that particular quorum are now null and void?
That is why I am sure this one you can take to an M-Pesa agent. Yeah. This one will succeed. The Supreme Court will uphold the legality of the IEBC, because if it goes otherwise, it means that all that the IEBC did was null and void, and that cannot be, because we had a decision of the High Court that mandated us to proceed. The mistake that the Court of Appeal did, and agreeing with the High Court, was that they decided to look at the IEBC statute and to look at the quorum of 5 as opposed to the quorum of 3 that the Constitution sets for commissions under Article 49. So I think there was a problem there. Yeah. But that one is one decision I'm sure about. I can smile about that one. At least we'll win that one. So going forward, then the other questions of whether you can take the president, whether a sitting president can be subject to proceedings when he's sitting. I think Judge Tuyot dissented in the Court of Appeal. That one is also an important one, because it will then define what happens to the president and future presidents, whether they'll be subject to process while in office, and whether the courts can then inquire into what they do on questions touching on their functions or their dual role as citizens of the Republic of Kenya and as sitting CEOs of the country. I think that's also a crucial one that will come. Okay. Otherwise, I'm sure the main thing is the basic structure doctrine. Once that is settled, then I think all the other questions will then follow. Okay. And then the BBI can then get back to life. Now the mode in which, how the BBI gets back to track will depend on what the Supreme Court decides on the basic structure, on the amendability and unamendability of certain provisions of the Constitution, and then now on process, because the basic structure then goes into the entire process. Yeah. And to follow the 4-tier process prescribed by the High Court and the Court of Appeal would mean going back to the drawing board. And remember, there's still another option that I'm sure the court will deal with. The question of using the route of Article 256, because I think this is a comprehensive appeal. Yeah. The court probably will also advise on how to amend the Constitution under Article 256, which is the parliamentary route, which I think was largely ignored, and which would have been used, in my view, to achieve certain quick amendments to the Constitution. Okay. I think we would then not be in this position. All right.
Omari, there's a question here related to what Senior Counsel is saying. Charlo Woodrose, he says, ask the panelists, what will happen to the upcoming election? Suppose the Supreme Court overruled the decision made by the previous court, terming the BBI null and void.
Trevor, I might be alone in this country with this view, but I'm entitled to this view. Yeah. The Supreme Court is a different court. Yeah. The lower courts, that is the High Court, and the Court of Appeal, are statutory-based approach courts. What does the law say? Supreme Courts worldwide are same political, philosophical courts. They will listen more to the world outside called Kenya than what is the law as it is. Any decision of the Supreme Court is like being cast on a stone. It is final. The Supreme Court of Kenya has ears what is happening. If you look at what Professor has told you, the lower court, the High Court, the Court of Appeal never looked at what will be the repercussions of their decision to the economy of this country, to the stability of this country, to the future of this country. The Supreme Court must listen to it. For example, when you look at the decisions of presidential decisions of Mutunga, Maraga 1 and Maraga 2, they were decisions based on what was happening outside the court. In my own view, and this is, as I said, I might be wrong, The Supreme Court will now be making a decision when proper political formations have taken force. During the BBI one at the High Court, 90% perception-wise was that Kenyans didn't want the BBI. William Ruto was ahead with that narrative. So the BBI was bound to fail based on that over 95% of Kenyans were not interested in the BBI. At the decision of the Court of Appeal, a similar narrative was there that, look, a greater percentage of Kenyans was not interested in the BBI. Now we have a serious question that is coming up. The Raila Odinga and Uhuru have raised the political claim to the narrative, and they are continued saying that the BBI went for half-term. It is going to come back. They have a serious national constituency that now is almost half-half. If the Azimio team continues the speed at which Professor is one of them, is doing a good job. And I don't know, Trevor, if Steve, my brother, was not contesting, I would have gone to vote for him in CI as a senator. If the move moves, the 7 judges are seeing what is happening. It's likely to be they will make a decision in favor of who and which side represents the majority of Kenyans. This is worldwide. The questions of gay, the questions of homosexuality, the questions of religion that have been decided, the question all over worldwide, Supreme Courts listen to the wishes of the majority. They don't want to make a decision that will be rejected and opposed by the greater constituency. And therefore, there is a likelihood the BBI decision will be reversed based on the politics and the future of this country. Number 2, what will be the political ramifications and what will it be if the decision is not reversed, or if it is reversed, or if it is reversed partially? Yes. 1, if this decision is upheld, the William Ruto team will have one argument. We told you, you wanted to push an illegality. The Supreme Court has spoken. They will carry their day. But also the Raila team will say, Kenyans, these people have denied you money that we were bringing. These are not the right people to be given this position. So both sides, it cuts both sides. If the decision is reversed, the momentum of Azimio will not be stopped. It will move in a speed that will vanquish William Ruto and his team. Because they will now be saying, give us this. The question that Kenyans are not saying, can the Supreme Court stop the elections of 20 of September? If it reverses this decision, without being prompted, the Supreme Court can say, we will allow implementation of our judgment. Because we cannot make a judgment, an academic judgment, that is not going to be implemented. We will allow implementation of this decision that we have given for 8 months or for 1 year. They not talk about before any actor takes the mandate. So there is a possibility the election of August 20, this election that we are coming, if there is a reversal, the Constitution, and that is an advisory, the first election that we did in 2013, the Supreme Court changed and gave an advisory that the election should move from August to December. They are clothed with that power. So the question to me is, what will be the import of this judgment? The Supreme Court, and they listen a lot. Somebody told me they listen and watch Trevor so much, daybreak news. The Supreme Court should balance the interest of every Kenyan.
Yeah.
Every Kenyan should be a winner in the decision that they will be. So they must allow others, and they must not allow everything. No. Because if they allow everything, then their decision will polarize the country.
All right.
They will play the middle line, but fundamentally, I don't want to deal with any matter, because they might say I'm discussing a matter that is live before the court. But in my own view, from my look at jurisprudence coming from other decisions, the BBI will be reversed.
Okay.
Once it is reversed, then we will see modalities provided and a roadmap provided, so that there is because in commercial transactions, you don't get a judgment and you do not get to eat the fruits of your judgment.
All right.
So the Supreme Court must get how to get Kenyans to get the fruits of the decision that they'll come up with.
Okay, gentlemen, we ran out of time, but I know senior counsel protocol demands that you give the closing remarks. But let me see what you're saying online really quick before we come to you for closing remarks here. Mungai Jack says, I found it abnormal that for the whole day, no single judge asked a question. I hope the judges are not under pressure to decide in a certain way. They seem to be in a hurry. For what exactly? Okay. Let's see what else you're saying. Weke Alan says, the way the Supreme Court will handle the BBI will have a huge impact on the confidence of the citizens. The seeds of mistrust will sprout later this year, and the fruits will be bitter. Remember 2007, all right? Okelo Molimu says, whoever revived the BBI case should have let it go in order to allow the two brothers concentrate on Azimio without divided attention. Even if their prayers were to be granted, there'd be no time to implement the document. Let's move on. Okay. Engineer Lazaro says, I don't believe in the judiciary. Their verdicts currently being influenced by the politics on the ground. Okay. J.M. Musoma says, the arrest of Jimmy Wanjigi opens up the bureaucracy in the hierarchy in our courts. We should not have two orders from the same government department giving different instructions on the same case. Why don't they digitalize this process? Chalo Woodrozy says, there's no political witch hunting on Jimmy Wanjigi's situation. Let him argue his case before the court, and if he's innocent, he will be set free. He should stop mixing politics with his dubious personal activities. Let the law take its course, all right? I believe that's where we leave it now. Prof, closing remarks on this.
Thank you, Trevor. I think in closing, I just want to agree with learned friend on the question of the implications of the decision of the Supreme Court and the importance of that decision. Now, the implication is that it will have a political connotation. Either way, I can assure you it will. And I'm sure the Supreme Court is likely to do a balancing act. The balancing act will be to set aside certain findings, including, I'm sure, the finding on the basic structure, and perhaps the finding on the IBC, I'm sure about that one, the finding on the basic structure, and then it will leave intact certain other findings. It will make it easier for the BBI process to be revived, because the Court of Appeal had found that the committee set up by His Excellency the President as legality, as a legal routing, and therefore it is only the question of time that will define when BBI will start again. But BBI has very good things, as I've always said, and I think that it should be given an opportunity to commence. And I think the people of this country should appreciate that out of the BBI, the 47 counties were going to benefit out of the additional finding of 35% of government revenue sent from the central coffers to the counties.
All right.
Thank you.
Senior Counsel, we have to leave it there. Professor Tomo Gienda, Senior Counsel and Advocate of the High Court, and Dan Stanomari, Advocate of the High Court. It's a 3-day hearing marathon of the BBI Supreme battle. Continues today and tomorrow as well. We'll keep you updated all through the process. Now we take a quick break. When we come back, Willis Bazura Buru is here with health and lifestyle. There's no skin by Lydia. You're the one who started this, Omari. You said the Senior Counsel has to close.
This is what the Supreme Court did. I need fair. Only 1 minute. Say the final one.
We've really run out of time, but if you have 1 second.
Only 1 second.
Go ahead.
Kenyans, Happy New Year. And may we celebrate, may we vote, may we listen to the judgment in peace as citizens. I am condemning any form of violence in political activities. That is all I was saying.
Those are your final submissions?
That's my final submission.
I didn't want to be sued, so I don't know. Okay, I guess Lydia Nyaga is already here. She's a beauty therapist. She'll be telling you how to stay beautiful. All right? See you in a bit.